But I'd just like to tell you this, that the Special Marriage Act was a law which was enacted by Parliament, and the purpose of the law was to allow for couples belonging to different religious faiths to enter into marriage. Now, the law uses the expression man and woman. So the law is very clear. It contemplates a marriage in a heterosexual relationship. It provides for a variety of other things, including succession, including things like which are the prohibited relationships which cannot enter into a marriage for men and women separately. Separate ages of marriage for men and separate ages of marriage for women. So what we felt was that nobody wanted the law to be challenged, because if the law was struck down, you'd be in a situation where there would be no governing principle allowing for couples of different faiths to get married, which the Special Marriage Act does. So here you have a law which specifically uses the words man and woman. Can the court then override the provisions of that law and read that as man and man or woman and woman? And we said we can't do it. Now, another aspect which I must emphasize is that the entire gamut or domain of marriage is governed by legislation in India across communities. Now, therefore, we felt that if you have to recognize same-sex marriages, this is something which has to be done by Parliament, which is entrusted with the duty of lawmaking. But I must also share with you that I was in a minority in that case on a certain specific aspect, because I believed that the court should recognize at least the right to form civil unions for same-sex couples until such time as Parliament stepped in and legislated on the subject. 3 of my colleagues didn't agree with us. They felt that even the recognition of same-sex unions was beyond the purview of the court. But having said this, and I'll leave the question with just this thought, that what happens in courts in modern democracies is not only to be looked at in terms of the substantive outcomes of a case. The court is involved in a continuous process of dialogue. A dialogue not only with the litigating parties, but a dialogue with wider civil society. And that's one of the reasons why we have now decided to live stream our important constitutional cases. Because as Chief Justice of India, it has been my very firm conviction that we need to take the process of justicing and the administration of law to the homes and hearts of people. People must understand that the smallest issues which come up before the courts attract the most serious of application of mind. And in this case, I do believe that between the date when we decriminalized homosexuality in Navteej Singh Johar and today, there's a wider societal acceptance of these relationships. And I do think, speaking for myself as a judge, that there is so much which has to be done by society itself and by other wings in a modern democracy. You cannot look to the courts to resolve every issue of dispute that may arise in society. It's important as judges that we draw the line and decide what legitimately belongs to our jurisdiction and what legitimately belongs to other wings of society, including civil society itself.